Hi everyone. Today's class we are going to discuss about the infringement of IPR. Let me move towards this slide. So the topics we are going to discuss in today's class is definition of an infringement, and we are going to explain the various steps of infringement with the help of case study. So before going to discuss the topic, we will have a quick recap of what we have discussed earlier. That is the classification of an intellectual property rights. So the intellectual property right is classified broadly into two categories. Okay, so based upon the creator works and its application. Okay, so it is classified into industrial property and artistic work. The industrial property is further classified into patent, trademarks, industrial design, trade secrets, and the artistic work is further classified into copyrights, geographical indications. So this is the classification of an IPR. Okay, so if a person has a creativity work, he can apply for the intellectual property rights. Okay, so what is the need to apply for an intellectual property rights? Because he can get an exclusive rights for a period of duration. Okay, so that he can enjoy the benefit of his creativity work. Okay, for example, if you take patent, the duration is 20 years. So if he create any works, he can enjoy the exclusive right for the period of 20 years. So he can decide who can sell the product, who can for whom we want to give the license to sell the product. Like that, he can have the exclusive rights. Okay. If you take copyrights, if he wrote any books, okay, so he have an exclusive right for the period of lifetime of an author plus 60 years. So after the death also he can able to enjoy the rights because of the intellectual property rights. So this is the classification. Okay. So why we have bring this classification in this topic? Because we should know what is the intellectual property rights, what is the classification, what is the exclusive rights they have when they have a creative work. Okay. So what happen if anyone unauthorizedly use your exclusive rights? There came our topic. Okay. So if you have an exclusive rights for a period of 20 years if you invented a product. Okay. If anyone unauthorizedly use your patent product, then how you will then how you will get the then how you will get the compensation. Okay, there the definition is coming. Okay, so infringement is nothing but the violation. Okay, so violation of an intellectual property rights is known as the infringement. How the violation is happening in the intellectual property rights? So if anyone unauthorizedly used your creativity work, then violation is happening there. Okay, so that violation we will call as an infringement. So this is the definition of an infringement. So infringement is the violation of an IPR. Okay. So there are various types of infringement. Okay, based upon previous classifications. First one we will see about the copyright infringement. Okay. So previously we have discussed what is copyright. Okay, so we will give a copyrighted for any work. Okay, for any creative works we will give the copyright. Okay, so the person can enjoy the duration of lifetime of an author plus 60 years. If anyone violates your right, okay, for example, if you are writing any book, okay, or any novel, okay, so you have the rights to sell the novel, and you can rights to reproduce the novel. Okay, if anyone unauthorizedly reproduce your book or novel, then there is violation is happening. That violation we will call it as an infringement. Okay, so if you see the screen, you can able to see when someone reproduces, distributes, perform, or display the copyrighted work without the authorization of the owner. So that infringement is happening. Okay, so we can explain this infringement with the help of case study. So the case study we are going to discuss is two case studies. One is Telegram case Then another one is Sophia Stewart lawsuit. So Telegram cases, what means Telegram is a social app. Okay. So who from which we can able to share the messages. Okay. So the production house, various production house filed a case against the Telegram, state that in Telegram app they are sharing the copyrighted content, so that the user can able to download the copyright content without the authorization of the owner. Okay, so they can able to download some movies or something with the help of Telegram app. So they filed the case. Okay, so the court analyzed the case and insisted the Telegram to prevent such type of sharing the copyrighted content. They're asking to increase their security in the platform. Okay, sharing platform. So the case is still running. The case is filed in 2021. So that is one example of an copyright infringement. The another case study is Sophia Stewart lawsuit. Okay, the Sophia Stewart is an author who wrote the book Third Eye. Okay, so she filed a case against the Warner Brothers, state that the film directed and produced in the Warner Brothers production, The Matrix, is the story is based upon the novel Third Eye. So she filed the case against the Warner Brothers, states that her novel is transformed into a film without his knowledge. Okay. So the court analyzed the case and find out that there is not more similarities based upon the novel and the film, and the court dismissed the case. So these two cases are the example for an infringements happening in the copyrights. Next, we will see about the another type of infringement, namely trademark infringement. Okay. So in trademark infringements, what is happening means uh, we know what is trademark. So trademark is the mark given for product identification. Okay. So that is the main purpose. So you want to identify the product. Okay. So how we can able to infringement? How we can able to violate in the trademark? Okay. So to create a confusion. Okay. So you can't able to identify the product clearly. That is the infringements happening in the trademark. Okay, so here you can see the case study. Example, India wins the trademark case for ponni rice against Malaysian company. Okay, so this case is happening in Malaysia. A famous company in Malaysia has registered the trademark in the name of ponni rice. Okay, so they're selling the rice packet in the name of ponni rice in the and distributing their rice packets in the Malaysia. Okay. So the Indian farmers, mainly the South Indian farmers, especially known for their ponni rice, has filed the case against the Malaysian company. States that they because of the trademark registrations, they are having the losses in their product. So the Malaysian company getting the rice from various countries like Thailand, India, Pakistan, and selling the rice in the name of ponni rice to the distributor. Okay, so they are not giving the quality of the product as mentioned the ponni rice. So the ponni rice is mainly get the name from the South India. Okay, so they filed the case. The court analyzes the case and dismissed the Malaysian company, and they asked to stop the Malaysian company for further distribution of the pony rice. So this is one of the infringements in the trademark. So next we will move towards the patent infringement. So what infringement happening in the patent? Okay. So we know what is patent. Patent is given for an invention product. Okay. Uh, how the infringement may happen? Okay. So if I'm developing a product, I can make a copy of that and I can able to sell that product. Okay. Without the permission from the owner. That is the patent infringements. So this patent infringements can happen in two ways. One is direct and another one is indirect. In direct methods, we can have further classification that literal. So literally they are copying. So if a person X is developing a product, uh, the product is literally copied and they are selling the product. That is the literal classification. The second one is doctrine of equivalence. So doctrine of equivalence is, for example, if a person using a two substances, chemical substances A and B, and he is doing analysis in the presence of an hydrochloric acid, and he is getting a product. Okay, for that product he is getting the patent. Okay, so another person using the same substance A and B, but instead of hydrochloric acid he uses any acid and getting the same product. Okay, so the process is same, but the presence of an acid only differ. Okay, so the end result also same. Okay, so he's not doing literally, but he is doing infringement. Okay, uh, that is known as a doctrine of equivalence. So how we can find out this doctrine of equivalence? From the function, what is the functions, if it is a purpose is same function, or if you're getting the same result test, then the infringement is happening. So this is the direct infringement. So another classification is indirect infringement. So how they are indirectly doing the infringement means by inducing any third parties to do the infringement, or by contributing the materials for the infringement. That is the indirect infringement. The last classification is willful infringement. So willful means intentionally you are doing, intentionally you are making a product without without getting the proper permission. That is known as willful infringements. So these are the classifications of infringements happening in the patent. Okay, so for that we are going to see an example of TVS versus Bajaj. Okay, so Bajaj has got a patent for the fuel injection system. Namely, you can able to see the screen DTSI. So that is a digital twin spark ignition. For that, Bajaj has got the patent. Okay, so the same fuel injection design is created by TVS, which is given the name as controlled combustion variable timing intelligence with the help of three-valve engine. Okay, so in the year of 2007. Okay, so they have designed another type of fuel injection in the TVS. Okay, so now Bajaj has filed the case against the TVS engine, states that they have copied their DTSI fuel injection system and renamed it as controlled combustion variable timing intelligence. Now what happening means, the court is analyzing case. Okay, so they have analyzed the case. They're saying that the process is same, but the placement of the material is different. So in TVS, the injection placement system is different, and they are using three-valve system. Okay, so that is entirely different from the digital twin spark engine that is for Bajaj. Okay, so the court dismissed the case. Okay, so this is one of the example of an patent infringement. Next, we will see about the industrial design infringement. So we know what is industrial design. So industrial design is mainly for an aesthetic view. Okay, so if any person create a confusion in this aesthetic view, visual appearance, then it is known as an infringement. So which leads to confusion. Okay, so you can able to see the screen, the two cups. Okay, it is made up of an same aesthetic view, but the color only changed. So this is one type of an infringement. So we will see a case study of an seller household product versus Modware India. So both these companies produced designing the water bottles. Okay, so seller household product designing a water bottle, and they are selling the product. So Modware also designing the same water bottle. So you can able to see the screen, the same water bottle, and they are also selling. So now seller household product filed the case against the Modware India, state that they are doing the industrial design infringement. So because of that, they are getting the losses. Okay, the court analyzed and asked the Modware to restrain the product. Okay, so this is one example for the industrial design infringement. Okay. So the next infringement is the geographical infringement. That is geographical indication infringement. So we know what is geographical indications. So it is basically the origin of the product. Okay, so the product is origin from a particular origin. Okay, so because of that they are giving the geographical indications. Okay, so how we get the infringement in this means, if you are selling the product without the geographical indications, then the quality will be reduced. Okay, so which will lead to the confusions. Okay, without the permission of from the holders, if you are selling a product, then which will lead to confusions. So here the case study is T-board versus ITC Limited. So T-board means here normally we will discuss about the Darjeeling tea. Okay, so Darjeeling tea famous for its aroma and taste because of the soil nature uh, nature occurring in the Darjeeling area. Okay, so they have filed the case against the ITC Limited. Okay, so ITC is having the various products. So they have a hotel in Calcutta, and in that for a particular launch, they have given the name as a Darjeeling launch. Okay. The T-Boot company filed the case against ITZ for using the word Darjeeling. Okay, so the court analyzed the case and find out that the Darjeeling launch they are providing various beverages, but it is not linked with the Darjeeling tea. So the case is dismissed. So this is one of the type of an infringements. Okay, the last one is trade secret infringement. So what is trade secret? We know. Okay. So if the secret is revealed, then the infringement is happening. Okay. So you can able to see when someone misappropriate or unlawfully acquires and uses the trade secret without the consent of owner. Okay. Then infringement is happening. So here you can able to see the case study Aptech. So Aptech is a company which is doing the electroplating in the internal surface of the cylinder. Okay, so their employee is working for a period of 15 years, and then he is retired and he started his own job doing the same electroplating. Now Aptech company filed a case against the person X in the court. The court analyzed initially and asked the person to stop making the further production. The person again moved to the High Court and asked that, and he filed the case. Now the court inquired. Now the person is telling that electroplating is a common method which is used, and during the period from where he is working in the Aptech company, they have not given any non-disclosure sign or non-competition sign. They have not got. So it is not coming under the trade secret infringement. So now the court is dismissed the case because the Aptech company not given any proper information about the what is the trade secret to his employee. For that the case is dismissed. Okay, so these are the various types of infringements we have seen. Okay, so copyright infringement, patent infringement, trademark infringement, trade secret, and geographical infringement. So in next we will see about the enforcement of IPR. So how we are going to stop this and how we are going to get the monetary benefit if anyone do unauthorizedly used, or how we can able to um, stop the infringement with the help of a legal framework. Okay, so we will see in the next class. Thank you.